Sir, I was interested in judiciary since very long time. Mostly when I was 10 or 12, my father is in judicial services. He's a retired judicial officer. So I have seen that culture and I was very much interested in the law. And the sense of doing something for the society, doing something, giving back to the society, and the sense of justice is embedded in me. And that
All
was
right.
the main motive for me to pursue law and to prepare for judicial services.
All right. All right. Where is your father? Where was your father posted?
Sir, he is retired from Ghazipur. He was in tribunal, motor vehicle tribunal.
Okay.
Yes,
Okay.
yes.
Okay. At the time of superannuation.
Sir, that I'm not sure of, but uh, promotions were due for session judge.
Okay.
And
All right. All right. All right.
yes.
All right. So, all right. Then, post your selection,
Yes.
you'll either be posted on civil side or criminal side.
Yes.
So, what is the standard of proof in criminal cases and civil cases?
So the standard of proof in criminal cases is beyond reasonable doubt, and standard of proof in civil cases is preponderance of probability.
What does that actually mean?
Sir, for criminal cases, the burden
So,
of
suppose uh, in criminal case, all right, there is a statute governing the offenses, punishment is provided for, all right. But in civil cases, suppose A says, I am the owner of this property, but uh, there is no documentary evidence, or there is a registered document. Suppose there is a registered title document in his favor. There is B who says I am also a owner, but the sale deed in my favor is not registered. So, how do you balance and decide?
Sir, in civil cases, the burden of proof is preponderance of probability. That is the inclination towards one person because of probability. So since A is having a registered document, so court will be inclined towards him, and since B can't produce any document in his favor, and the person who is asking for a court to do something should produce the document for it, should produce evidence for it.
Which
And
which
since
which is
B,
which is that provision which says so?
sir, sir, I'm not sure, but 102 of Indian Evidence Act.
Precisely 101, all right, 101 says that, but 102 says in case no evidence is led on either side, then what is the consequence?
Yes.
All right. And in criminal cases, when we say it has to be beyond reasonable doubt,
Yes.
are we talking of any and every doubt?
Sir, beyond reasonable doubt means that the conviction of guilt should be 100%. That is, there is no other possibility that someone else could have done it. So, if the prosecution can prove the case that 100% the act is done by the accused, then only he can be convicted. If any possibility is left, then court will be adversarial. Since it is adversarial system, court will be more towards inclined towards accused.
All right, all right. Then, broadly speaking, how many types of cases are there in under the criminal procedure code?
Sir, so first is in on FIR, if the report is given by the police.
Like classification of cases. All right, all right. First is on the basis of registration of FIR.
Yes, sir. So there is cognizable case and non-cognizable cases.
All right, all
So
right.
there is
So
bailable,
FIR would get registered in case of.
sir, cognizable case.
All right, all right, all right.
And so
Then,
there is on the basis of bail, that is bailable and non-bailable offenses.
all right.
And sir,
On the
on the
pursuant to the quantum of punishment provided for.
sir, summon cases and warrant cases. If it is
All
more
right,
than 2 years, it's warrant cases. If less than two, then summon cases.
all right. What is the system of trial? System of trial.
So system of trial is first is trial by court of session, then is trial instituted on police report, trial instituted on complaint, and summary trial, and some summon cases.
Summons cases. All right. Is the requirement of framing a charge a must?
So framing of charge is essential for um, court of session trial.
Not before a magistrate?
Sir, sir, as far as I can remember, it is not an essential for summary trial to frame charge. Otherwise, charge is framed.
Summary, I'm talking of maybe there is a warrant case triable by a magistrate.
Yes, sir.
Obviously, it would be punishable with more than 2 years of imprisonment, but
Yes,
a
sir.
magistrate of first class cannot impose punishment of more than 3 years.
Yes, sir.
But still, he can try.
Yes, sir.
Offense of uh, 326 326 is punishable with life imprisonment, or maybe 409. So, uh, but they can be tried by the
Yes.
magisterial court.
Yes, sir.
So,
So,
so
yes, sir. So
framing
charges are framed by a magistrate as well.
magistrate also. All right, all right. And then suppose if it's punishable with only 2 years of imprisonment.
Sir, that is summon cases. Sir, I'm not sure, but charges are not framed in summon cases.
Okay, then what else is done in suppose if no charge is framed,
Yes, sir.
then of course you'll have to tell him the accusation of which he is facing the trial.
Yes, sir.
Under which provision would you do that?
Sorry, sir, I can't
All
recall the
right,
provision right now.
all right, all right, all right. Then you have to give a notice to the accused under section 251 CRPC, because notice of accusation of he has to be informed of.
Yes, sir.
Formal framing of charge may not be required. All
Yes, sir.
right. So,
Yes,
all
sir.
right. That's all from my side at the moment. Pramod ji next will ask you. Thank you.
Thank you, sir.
Thank you.
Good morning, Anusha.
Good morning, sir.
It's nice to know that you are from a judicial family and you are planning to join the judiciary to serve a social cause.
Yes, sir.
Okay. Mr. Padamkant has asked you some question on criminal side. I will ask you a question on the civil side.
Thank you, sir.
Tell me whether a tenant who has been dispossessed forcibly by a landlord
Yes, sir.
can if can you file a suit for recovery of possession? If yes,
Ye-
what is the limitation for it? And when
Sir,
will be checked?
sir, he can file suit for disposition within 6 months, as per specific relief act.
Okay, that is section 6 of
Yes, the
Specific
section
Relief
6 of
Act. Yes.
specific relief act.
Okay, fine. Okay, tell me, in a case, can a sale deed of a property be challenged by a legal heir of a property owner after, say, 20 years or 25 years on ground of fraud?
Sir, I'm not sure, but if it can be proved that sale deed was based on fraud or collision, sir, then I
What
believe,
is the limitation period under law?
sir, sir, I'm not sure. Maybe 3 years, sir. I'm not sure. Limitation
3
period.
years from which date?
Sir, from the date he has came to know about the fraud or whatever fact he is stating that the ground should be for the sale deed rejection. So, sir, since his knowledge, then 3 years should be calculated.
So what you are saying is 3 years from the date of discovery of fraud.
Yes, sir.
And how the fraud has taken place, whether it has to be pleaded and proved or not, or mere allegation is enough.
No, sir, it should be proved.
And
But,
pleaded or not.
Sir, sir, as far as I can remember, in Order 6, uh, it should not be given, the manner should not be pleaded, but it would be proved later.
Are you sure? Without pleading a fact, how can you prove it?
Sir, he has to plead that fraud has taken place, but
How fraud has taken place? It has to be pleaded first.
yes,
Then
sir,
only
but
you can lead
manner,
evidence on
sir,
that
I'm not
point.
sure.
Okay. But under law, a fact has to be pleaded first and then
Yes,
proved.
sir.
Both are essential requirements under law.
Yes, sir.
Okay. And the limitation period, as you correctly said, starts from the date of discovery of fraud, and it is 3 years. And there are many Supreme Court judgments on this point, that such a the limitation of 3 years applies only to the original owner, but to a legal heir, this limitation of 3 years commences from the date the fraud is discovered. All right, that's fine. Okay, do we have time for another question? Okay, tell me, there was a case of a deportation of some people from America.
Yes, sir.
These people landed in India and they were treated in inhuman conditions by the deporting country. And when they landed, they were arrested by Indian police. Tell me, as a judge, suppose this case comes to you for bail. What is your stand? How will you deal with it? These people who were arrested, are they offenders under Indian law, or are they victims of some fraud? Or is there some violation of international law or some municipal law of a country? Is there some violation of Indian law here also? Because the facts as they are emerging, these people, some of them, did not have any forged visa of any country. You understand? There are many countries where visa is available on arrival.
Yes, sir.
Like Thailand.
Yes,
If
sir.
if Indian passport holder travels to Thailand, there is no visa requirement, and he
Yes, sir.
can take a flight from Delhi to Thailand without any visa. But there
Yes,
are other countries where there is a requirement of a valid visa
yes,
being obtained first before you embark on your journey.
yes, sir.
Okay, like America. If
Yes,
you take a direct flight from Delhi to America, some city in America, you have to have a valid visa. So these
yes,
two cases are different. In case of America, if suppose the traveler is having a forged visa, which is arranged by some agent to whom he paid
yes,
a huge amount of money, okay, then there is a forged visa on his passport. Then this case is different from a case where he travels to Thailand or Bangkok, where there is no requirement of any visa, but he
yes,
has
sir.
paid money to an agent. So such a
Yes,
case, tell me if you can distinguish the two cases, and whether in the eyes of Indian law he has committed any offense. And how will you, suppose such a person is produced before you for bail, how will you deal with such a case of bail?
sir. First thing that would come in my mind is that no person should be treated inhumanly, and there are certain rights given to a arrested person as well. So first thing, I'll make sure that these rights are addressed to them, and they should know that what are their rights are. They should know on the grounds they are arrested, and they should not be treated inhumanly. And so second thing, regarding if they
But
have
but but
committed,
that, but that is the protocol of standard operating procedure of that country. When somebody is caught in illegally living in a country, it is their procedure that they catch them and they handcuff them and chain them, and
yes,
that
sir.
is how they are deported. There is no
Sir,
violation of American law. There
okay,
may
sir,
be
sir,
some
but
violation of
yes,
Indian
sir.
law, but there are human rights available to everyone,
Yes, sir. Yes,
including
sir.
prisoners of war. He was not a
Yes, sir.
prisoner of any kind. He
Yes,
was
sir.
a deportee. That may be
Yes, sir.
some violation. And my question is that such a person, when he lands in India, he's arrested by Indian police, and then
Yes.
he's produced before a court of law, and he applies for bail. How will you deal with such a case? Is he an offender under Indian law? Is he a victim, or is he a beneficiary of some kind of crime?
No, sir, I don't think so. He's a victim because in IPC also, a person who commits an offense outside country, he can be tried in India, but he has not committed any offense. So, and bail is the rule. So,
He has
I would
not committed
just
any
put,
offense.
sir, they tried to get there, and there is no
Because
visa
he
on
is
arrival.
traveling to America
So,
on a forged visa. Is he not a beneficiary of that forgery? He may be a victim on the one hand, that he
yes,
paid money to an agent and he was duped by this agent, that having taken huge sum of money. He got him a forged visa on which he was caught and deported.
Yes, sir,
But
he
then
can
he's
be
also a
beneficiary.
beneficiary.
Yes, sir, it can be included in forgery.
So that is why he's arrested. What will be your stand? Will you grant him bail, or how will you deal with it?
Sir, I can't remember right now if forgery is a bailable offense or not, but if forgery is a bailable offense, so they shall be granted bail.
Okay, fine. That's all from me at the moment.
Yes, Anusha. So is this your first attempt, Anusha?
Good morning, ma'am. Yes, ma'am, this is my first attempt.
Don't you think you are too young to join judicial services?
No, ma'am, I don't think so because I've completed my law in 2019 and thereafter, due to some personal reasons, my preparation was discontinued. So I think I've been in this process for a very long time. And yes, there might be some lapses on the part of practical experience, which I think can be, that bridge can be gapped by training and by seniors.
Good. Now the next question is that when Padam sir asked you that why you want to join judicial services, you said
Yes,
that you want to serve society.
yes, ma'am.
And why not you join NGO or any organization to serve the society?
Ma'am, my basic skills, which I have worked on for last 10 years, that is from 2014, I am in law college and legal field. So these are the skills I'm sharpening, and I would like to contribute to the society with my skills. And that skill is,
That could have been done by providing free legal aid also.
ma'am, that I have been part of such aids and campaigns in my colleges as well. But I aspire to become a judicial officer, and that aligns with my eternal goal, that is to serve the society. So I think judiciary would be a better option for me to align
And
with goals.
And what about the different truth that a handsome salary that you're going to get and the privileges that you're going to get for which you have been working hard?
Ma'am, these are the byproducts of the job I'm preparing for, but these are not the actual means I'm working for. They are just the accessories with the job coming. But my main goal to join judicial services is to use my skills and my knowledge for something that I can do for society. That can be done with NGO, but I have keen interest in law, and I would like to help by those means only. That is my judicial skills.
Okay, Anusha, since we are living in 21st century and we have already witnessed an era of artificial intelligence.
Yes, ma'am.
So with artificial intelligence, we can expect that there can be a rise in cybercrime also. So what do you
Yes.
understand by cybercrime?
Ma'am, cyber crimes ma'am, cyber crimes is a very dynamic concept, and fraudsters are also emerging with very new ideas. So I believe in every 2 to 3 years, the definition of cybercrime is changing. But talking about right now, phishing and digital arrest, identity theft, these are all the means for cyber crimes. And these people, because social media has become part of our day-to-day life, and we can't remove it. So what we can do is to create awareness and to let people know how to protect themselves. And it is not only limited to personal theft or personal identity issues, but they are also taking our money and all these cyber frauds. So
Okay. Okay, Anusha. Next question is that you have read one section, section 303 in IPC. In which landmark case was that held unconstitutional? 303, that is murder by life convict.
yes, ma'am. Sorry, ma'am, I just can't recall
Okay,
the.
you remember that it was held unconstitutional. It
Yes,
was held
ma'am.
unconstitutional in the case of Mithu versus State of Punjab.
Yes, ma'am.
But that section still holds a place in BNS in the form of section 104. Why?
Sorry, ma'am, I'm not that well aware with BNS sections right now.
Okay, so on what grounds was it held unconstitutional under IPC 303? Any idea?
Sorry, ma'am. I
No
can't
issue.
recall it right now.
Okay. Next question is that for dying declaration under section 32, is the expectation of death necessary?
No, ma'am.
It is not necessary.
No, ma'am. Ma'am,
Okay.
it was held in Pakla Narayan Swami that it is not essential that there should be apprehension of death at that time. Any statement made prior to it also can be considered as dying declaration after the death, if it indicates the reason for death.
Okay. what type of property or what is the nature of the property with respect against which an offense can be committed in the segment of extortion? For extortion, what is the actual nature of the property?
Ma'am, for extortion, it can be any sort of property. It can be valuable security. It can be any documents.
It can be
And
movable, immovable, both.
yes, ma'am, it can be asked for valuable security, can be for immovable property documents as well.
Okay. And with respect to criminal misappropriation of property, what should be the nature of property?
Ma'am, movable property.
And with respect to criminal misappropriation of the property of a deceased person, what should be the nature of the property?
Ma'am, it is movable property. Regarding
Any property.
movable property, I'm not sure. So
Any property. Okay. No issue.
yes.
Okay. What is the major difference between criminal misappropriation of property and mischief? Okay. Let me give you an example. Okay. You're going through a street and you find a ring. Okay.
Yes, ma'am.
First situation is that you throw a ring into a river.
Yes,
And the
ma'am.
second situation is that you pick up the that particular ring, you sell it in the market, and whatever proceeds you get, you use it for your own purpose.
Yes, ma'am.
So what is the difference between the two situations? Which situation amounts to mischief and which situation amounts to criminal misappropriation?
And first situation amounts to mischief because there is intent to annoy, and in the second situation it is criminal misappropriation of property, since the property belongs to someone else and I have appropriated it for myself. I have sell it and I have used that money, so that would amount to criminal misappropriation of property.
Can we say that the major difference between both of them lies on the grounds of wrongful gains and wrongful loss, wherein mischief, the only objective of the offender is wrongful loss and he gains nothing by throwing that particular ring into the river? And in criminal misappropriation, you gain something. At the same time,
Yes.
the victim also loses something. Okay.
Thank you. Yes, ma'am.
And what is your opinion about marital rape? And what is the status of marital rape in India? And should it be legalized or should it be made an offense in India?
Ma'am, marital rape is the matter which is sub judice in Honorable Supreme Court right now. The last I have read about it was 3 months ago when the then Chief Justice Justice D.Y. Chandrachud was going to retire. So the Honorable Supreme Court held that they would continue with the proceedings after his retirement, and since then they have not been commenced. And last Union government has filed their affidavit regarding the same, and prior to that, it was also a matter which was decided by Honorable Delhi High Court, where was a split decision given that majority, it was a division bench and it was a split verdict. And as far as my personal opinion is concerned, marital rape should be legalized, but I can't comment a lot on it because the matter is sub judice in the court right now.
But what is the legal provision with respect to marital rape in IPC, and what major change do you think has been done in BNS? Is there any case law which is contradictory to the provisions mentioned in IPC? Is there any age which is mentioned in IPC 375?
Yes, ma'am. If the wife is under 18 years of age and husband commits rape,
Is it 18 or 15?
ma'am, I think it's 15.
It's 15. And 18 was held in which case?
Ma'am, I can't.
Independent Thought versus Union of India. And the
Okay.
same age has been approved by the legislature, and the age of 15 years has been increased to 18 years in BNS. Okay.
Yes.
And marital rape above the age of 18 with the wife is not yet recognized as an offense. Okay.
Yes.
So do you think it should be recognized in India, and don't you think the law will enter into bedrooms?
Ma'am, that is why the matter is very controversial, because if it is
Okay,
we
what if tomorrow you become Chief Justice of India and you have to decide on marital rape? What do you consider that should it be made an offense? Will this somewhere save the marriages, and will it ensure that the trust of the people is reposed back into the sacrament relationship?
Ma'am, if I were the Chief Justice of India and if I have to deal with the case, ma'am, I think I would like to protect the rights of women as well, because there are many instances in household, and since such rapes and these are happening in the four walls of the bedroom, so people might not know the atrocities which are happening with the women right now. So I would not deal with it only because to save the sanctity of marriage, marital rape should not be considered as rape. There are many instances women are suffering a lot. We need to create a balance. What we can do is that presumption should be little more greater in such cases, but we can't exclude the fact that actually marital rape is happening in India and women are suffering a lot. They can't complain about it. And dowry and other cruelty is also marital rape is a part of cruelty, I believe.
Okay, I think we can sum up and we can move towards the feedback. And that was all, Anusha. Yes,
Thank you.
Padam sir and Pramod sir will let you know about the feedbacks.
Okay, thank you.
Burden of proof you dealt with rightly, but but whenever you see, as a judicial officer, while working on the criminal side, while working on the civil side, there is generally sufficient time before an officer to deal with the situation. While in criminal, it is of utmost importance. Post arrest, when a person is produced, the first thing is see how much importance the Constitution gives to the arrest. So whether the arrest is legal or illegal, that should be the first query.
Yes.
And have the grounds of arrest been informed to the arrestee forthwith? It's the constitutional provision says as soon as possible.
Yes.
And Honorable Delhi High Court in a case under PMLA recently held that when grounds of arrest were told to the arrestee just before production in the court, Honorable Court said, no, this is no compliance. And he was ordered to be released forthwith. So the first query has to be whether the facts alleged him amount to an offense under some law in India. Secondly, whether what is the punishment provided for, and whether the arrest is in accordance with law at the moment. This detention should not be by way of punishment, because that stage is yet to come.
Yes, sir.
Whether one is guilty, not guilty, one does not know.
Yes, sir.
And see, precisely for this reason, the legislation says that if for a particular offense, half the period one has undergone, then as a
Yes.
matter of right, you are entitled to grant of bail.
Yes.
So you rightly said grant of bail is the rule. That's the norm. And jail is an exception. And pleadings are very important in civil matters. Not that law has to be produced, but facts have to be pleaded. If not in very minute details, at least some broad facts have to be alleged. Because without pleading, evidence will have no value in the eyes of law. So facts have to be there. So, but in any case, and you see, you will be going to be interviewed by honorable judges of the High Court.
Yes.
So not that much grilling probably may be there, but you cannot hide something. If you do not know, you rightly said, I do not know. But from my side, you still did very well. Thank you. Thank you.
Thank you.
Okay, I also feel Anusha has a fairly good knowledge of law, even though in the matter of deportation of Indians, she gave an answer which perhaps, because I'll give you an example, a person who buys stolen property is considered a criminal in the eyes of law. All right. He may have innocently bought it, but then he's a criminal in the eyes of law and he's prosecuted and punished. Likewise, in the case of deportation of Indians, I gave you two situations.
Yes.
One of Thailand, where no visa is required. They haven't got any forged visa on their passports. And the other case was of Marital, where a forged visa, the person who travels is a beneficiary, and person who is a beneficiary of a forgery or a crime is also considered a criminal. And you can't let off a person who is produced before you on bail in those circumstances. Okay.
Okay.
This fine difference, razor-thin difference between two situations has to be understood as a judge. While granting bail, you can't grant him bail on the first date, because police would take remand and ask for time to investigate how the forgery was done, how a forged visa was arranged by. If you don't give time and these people don't join in investigation, they may even abscond. So that's not the right answer to grant him bail immediately on production before a court of law. Okay, but I wish you good luck. You have fairly good amount of knowledge.
Thank you, sir.
Yes, Anusha, coming to the positive sides first, there were many questions where you answered very precisely, and that is what is to be done. Don't stretch your answers too much. Jitna aata hai, utna bola, that's it. Second, expressions were very good. Smile, the constant smile that you had on your face, even when you did not know the answers. Andar jitna mehsoos ho raha hai, rehne do beta. Don't let your smile fade away with the questions or with the answers you don't know, or the questions that you're listening for the first time. Like Pramod sir asked you certain questions.
Yes.
Don't hesitate at all. And the fact that you avoided certain questions by saying sorry is a very good quality of yours, even if in maximum cases, like more than 50% you say sorry, doesn't matter, because the panel is going to judge you on the basis of your honesty and confidence. Don't mislead the panel. That's a very good quality of yours. And thoda sa, I think your body language, वैसे थोड़ा दूर बैठते तो we could have judged you better, but your body language with respect to nodding the head, इसको थोड़ा सा कम करें आप, right? You can see the panel also, Pramod sir, Padam sir, you can see. So try not to nod your head too much, but you need to communicate that vibe that yes sir, I do agree with you. So you can blink your eyes, slightly nod करें, okay? Don't roll your eyes if you don't know the answers. Ensure कि ऊपर वगैरह ऐसा नहीं है ना. Try to contact the panels, okay?
Okay.
And whenever you are asked a question with respect to your opinion, you said, I cannot frame an opinion. That's absolutely fine. There are times when we cannot have an opinion, but the panel will expect कि fact based चलो question का आपको answer नहीं आता, but certain topics जो अभी बहुत ज़्यादा highlight हो रहे हैं, they will expect certain opinion from your side. So ensure that you have a balanced approach. So when I asked you a question on the opinion based question, that was a marital rape, you had a balanced approach. So that was also good. And overall, I think it's very good. बस barracks का revision अच्छे से करते जाओ. And for sure, it's my experience, I'm telling you, panel में you'll get one, for sure, a judge who will try to roast you, who will try to confuse you. Don't worry. They are just checking your honesty. And also there can be chance that they might check you on the point of subordination. That do you accept with their point of view or not? Do you align with their point of view or not? So don't worry at all. Okay, that will be your time, and enjoy that time, and all the very best, Peter.
Thank you so much, ma'am. Thank you so much.